In this lecture, we're going to be covering chapters 13, 14, and 15 in our Ashcroft Law for Business textbook, starting with page 13-1, methods by which contracts are terminated. The first way a contract is terminated is that it is performed. The parties fulfill the contract, thereby discharging it. Certain factors for fulfillment would be the time of performance, the tender of performance, the tender of payment, satisfactory performance, and substantial performance. Contracts also can be discharged by operation of law. This can occur in bankruptcy, by the running of the statute of limitations, or by an alteration to the written contract. The parties can also agree not to carry out the contract terms. So just as two parties of their own free will enter into a contract, those same parties can agree to walk away from the contract, and that would discharge it. Other ways that contracts can be terminated, one would be impossibility of performance. No contract is ever made if the act is impossible to perform. Some common causes would be the destruction of the subject matter, new laws making the contract illegal, death, or the physical incapacity of the person that's supposed to render the services. Other ways that a contract can be terminated: acceptance of a breach of the contract by one of the parties. If the innocent party, so the non-breaching party, accepts the breach, the contract is discharged. When there is a breach in the contract, normally the party that has been aggrieved by the damages or by the breach in the contract can sue for damages. Those damages will be nominal damages, compensatory damages, punitive damages, and liquidated damages. Other remedies for breach of a contract would be to rescind the contract. Rescind means to set aside or cancel the contract. The aggrieved party may do so if the contract is breached. They can just set it aside or cancel it. A party can sue for specific performance of the contract. This is available in limited cases. Contracts for the performance of personal services will not be specifically ordered. 13-3 in our textbook discusses malpractice, which is a failure to perform with ability and care normally exercised by people in a profession, such as an accountant is liable to a client who suffers due to the accountant's malpractice. That gets us through chapter 13. We'll take a look at the questions at the end of the chapter. When are parties to a contract discharged by performance? Are all parties discharged simultaneously? Parties to a contract are discharged by performance as soon as they have done all that they have agreed to do. The other party or parties are not discharged if any material thing remains to be done by them. Question 2. If a contract states no time for performance, when must it be performed? If a contract states no time for performance, performance must ordinarily be rendered within a reasonable time. Question 3. What is the result if a tender of payment is refused? If a tender of payment is refused, the debt is not discharged. However, it does stop the running of interest, and if the creditor should bring suit, the person who has tendered the correct amount is not liable for court costs after the date of the tender. Question 4. What circumstances surrounding a deviation from a contract will a court weigh in determining whether there has been substantial performance of that contract? In determining whether there has been substantial performance when there has been a deviation from a contract, a court will weigh the significance of and the reasons for the deviation, the ease of correction, the extent to which the purpose of the contract is defeated, and the use or benefit to the owners of the work completed. Question 5. May a debt that has been outlawed by the statute of limitations ever be revived? A debt that has been outlawed by the statute of limitations may be revived by a written acknowledgement or promise to pay the debt by part payment after the debt was outlawed or by payment of the interest. Question 6. How free are the parties to contract to change their minds, and what is the result? The parties to a contract are as free to change their minds by mutual agreement as they are to agree in the first place, so that whenever they agree not to carry out its terms, the contract is discharged. Question 7. If a singer contracts to sing at a party, is the contract released if the singer develops laryngitis just before the party starts? Laryngitis would impair the singer's ability to perform satisfactorily and renders the contract void because of the impossibility of performance. Question 8. What is the effect of a force majeure clause? A force majeure clause in a contract excuses performance by a party when an extraordinary event outside the party's control occurs that prevents the party's performance of the contract. Think of a natural disaster like a tornado or a hurricane. Question 9. Does a breach of a contract terminate the contract? A breach of a contract does not terminate the contract unless the innocent party accepts the breach of the contract. Question 10. What is the theory that the law applies in determining compensatory damages? The theory that the law applies in determining compensatory damages is that an injured party should be paid for any loss that may have been sustained, but should not be permitted to profit from the other party's wrongdoing. Question 11. Under what circumstances is a court likely to compel specific performance of a contract? A court is likely to compel specific performance of a contract for the sale of real estate or for the sale of rare articles of personal property, such as a painting or an heirloom, the value of which cannot readily be determined. Question 12. Explain who might breach a contract because of malpractice. A professional person, such as a lawyer, accountant, or doctor, who makes a contract to perform professionally or professional services, has a duty to perform with the ability and care normally exercised by others in the profession. If a contract is not so performed, it is breached because of malpractice. Chapter 14 discusses the nature of personal property. In 14.1, we know the difference between personal property and real property by determining whether or not the property is movable. If you can pick up and move the property, it is personal property. If you cannot pick it up and move it, then it's going to be considered real property. Types of movable property are tangible, so something that you can hold, and intangible personal property. Methods of acquiring personal property. The most common would be to purchase some type of personal property. You can inherit, such as through a will or descent, or it can be gifted to you. No consideration is necessary when property is gifted or inherited. If the giver is a donor, the receiver is the donee. Other methods of acquiring personal property: accession, confusion, and creation. Creation would be some type of intellectual property. So it's some type of invention that someone has thought up. This type of personal property is going to be protected by either a patent, copyright, trademark, or a trade secret. 14.2h discusses lost and abandoned personal property. This is also a way that you can acquire personal property. Property that is abandoned can be acquired. Now, abandoned property is where the owner discards the property with no intention of reclaiming it. That can be distinguished from lost property, which cannot be acquired, at least not legally, by someone else. When a person loses personal property, this is where a person accidentally leaves the property somewhere, but they intend to reclaim it. 14-3 introduces us to bailments. A bailment is a transfer of physical possession of personal property on the condition that the property will be returned to the owner. So the owner never gives up ownership or title of the personal property. They're simply just giving up physical possession of the property for some reason. The bailor is the owner of the property. The person who takes possession is the acceptor, also known as the bailee. The bailment agreement is a contract between the owner, the bailor, and the acceptor, the bailee. The contract can be oral or written. Delivery and acceptance. There are two types. You can have actual delivery, where delivery and acceptance of the physical goods is done by the parties. But then there can also be constructive delivery and acceptance, where control over the goods is delivered and accepted, not necessarily by the parties, but maybe through some type of notice or receipt. Return of the bailed property. A bailment arises if the recipient does not return the actual goods. If a consignment exists, the holder may sell the property. If for repair, the property should be repaired and returned. So sometimes you will give your personal property to someone else to sell for you. That is a consignment. If you take your car to have the oil changed and you leave it there to have the oil changed and the tires rotated, well, that's a bailment in which the property is being repaired. And after the repairs are made, it should be returned. Other types of bailments, which are discussed in 14-7, would be for the bailor's sole benefit, a bailment for the bailee's sole benefit, mutual benefit bailments, and special mutual benefit bailments. Now, there can be a conversion of the bailed property by the bailee. A conversion is the unauthorized exercise of ownership rights. The bailee has no right, unless in consignment with the bailor, to sell, lease, or use the bailed property. Let's go through the questions for Chapter 14. So question 1A is, what is property? Property is anything that may be owned. 1B asks, may only the owner use property? A person may enter into a contract with the owner to use property without becoming the owner of the property. That is in line with the bailments that we just discussed. Question 2, what is the most common method of acquiring personal property? What other methods are there? The most common way in which property is acquired is through purchase. This occurs when the buyer pays the seller and the seller conveys the property to the buyer. Property may be acquired by purchase, possession, will, descent, gift, accession, confusion, and creation. Please note that all these terms are defined in your textbook. Can personal property be created? If so, how? Yes, intellectual property is created through human innovation in inventions, paintings, musical compositions, books, artwork, trade secrets, and other intellectual productions, giving its creator title for a period of years through patents for 14 or 20 years, and copyrights for the author's life plus 70 years. Intellectual property can also be protected by trademark and trade secret protection. Question 4, how may trade secrets be misappropriated, and how may a business legally acquire them? Trade secrets can be misappropriated by wrongfully acquiring, using, or disclosing them, but independently developing or discovering them is not misappropriation. Question 5, how has the internet caused problems for owners of intellectual property? The internet has generated problems for owners of intellectual property because it allows individuals to violate copyright law by quickly and easily copying and distributing huge amounts of intellectual property illegally. Question 6, what is the key factor in determining whether property is lost or abandoned? The difference between abandoned and lost property lies in the intention of the owner to part with the title to it. Question 7, when does a bailment occur? A bailment occurs when one party, usually the owner, transfers possession, but not the title, to the personal property to another. Question 8, give an example of a bailment where the bailee is not expected to return the bailed property in its original condition. Some examples include goods left to be processed and then returned to the bailor in processed condition, a consignment where goods are left but cash is expected in return, or items left for repair or cleaning. Question 9. What standard of care is required of a bailee in a bailment for the sole benefit of the bailor? In the case of a bailment for the sole benefit of the bailor, the bailee need exercise slight care and is liable only for gross negligence with respect to the property. Question 10. Explain the types of special mutual benefit bailments in which property is left as a security. The types of special mutual benefit bailments in which property is left as a security include pawns and pledges. In the case of pawns, tangible property is left as a security, most often for a loan. With a pledge, intangible property is left as a security, also usually for a monetary loan. Chapter 15 discusses special bailments. 15-1, carriers. Carriers engage in the business of transporting either goods or persons or both. Carrier of goods is a bailee. There are two types or classification of carriers: private carriers and common carriers. Private carriers are discussed in 15.1b. Common carriers are discussed in more detail on page 15.1c. The liability of common carriers of goods. Common carriers are liable unless damages are caused as an act of God. Think of the force majeure clause. Acts of public authority due to the inherent nature of the goods. Acts as the shipper. Acts of a public enemy. The liability of common carriers of goods is going to be oftentimes contractually limited in regards to liability. A carrier may limit its loss by agreement to a specified sum or to a specified percentage of the value. Most states permit carriers to exempt themselves from liability because of certain named hazards. Delay in transportation of livestock may result in serious losses or extra expense for feed. This is one type of liability that can be limited by a contract. The duration of the special liability. This lasts only during the transportation of the goods. Carrier as bailee before transportation. A carrier is liable only as a mutual benefit bailee until goods are ready for transportation. Carrier as bailee after transportation. If the consignee does not accept the goods after a reasonable time, knowing the goods have arrived, the carrier is liable only as a mutual benefit bailee. 15-2K discusses bills of lading. There are two types of bills of lading: a straight non-negotiable bill of lading, which is a contract requiring delivery of shipped goods to the consignee only. Then an order or a negotiable bill of lading is a contract allowing delivery of shipped goods to a bearer. 15-2L discusses common carriers of people. Common carriers of people have a right to prescribe the place and time, the payment of fares, and to prescribe reasonable rules of conduct while transporting. They have the right to remove passengers and the right to reserve spaces in the mode of transportation. Liability of common carrier of people in 15-2M. They're liable until the passenger leaves the mode of transportation at the end of the journey, and they're only liable if the injured party can show the common carrier was negligent. Duties of common carriers or people include the duty to provide reasonable accommodations and services, the duty to provide reasonable protection to the passengers. In regards to baggage, which are articles necessary for personal convenience while traveling, a carrier may charge extra for the amount of baggage a person brings. Carriers have limited liability regarding baggage, and it's usually going to be limited to some fixed amount. 15-3 discusses hotel keepers. It defines guest. A guest is a transient received by the hotel for accommodations. The relationship between the hotel keeper and the guest begins when the hotel receives the guest, and it terminates when the guest leaves or makes a permanent residence in the hotel. Some of the duties of a hotel keeper: to serve all who apply, to protect the guest person, and to care for the guest's property. 15-3E discusses the duty to care for the guest's property for losses resulting from an act of God, act of a public enemy, act of public authority, act of a guest, or inherent nature of the property. The hotel keeper is going to not be liable for losses that are caused by any of those acts. A hotel keeper has a lien on baggage of guests, and it applies to all apparel not actually being worn. So if a guest fails to pay, the hotel keeper would assert a lien against the baggage until the bill is paid. If the bill is not paid within a reasonable time, the hotel keeper may sell whatever's in the luggage and the luggage itself to cover those charges. Let's go through the questions at the end of chapter 15. Question 1, why are some bailments called extraordinary bailments? Some bailments are called extraordinary bailments because they are mutual benefit bailments in which the bailee, under the common law, is held to a higher than normal standard of care for the bailed property. Question 2, what is the difference between a private carrier and a common carrier? A private carrier transports goods or persons under special arrangements and may refuse service, whereas a common carrier transports goods or persons without discrimination for all who apply for service. Question 3. Why are common carriers regulated by the government as to their prices, services, equipment, and other operational policies? Common carriers are regulated by the government as to their prices, services, equipment, and other operational policies because they are public monopolies and the regulation is in lieu of competition as a determinant of their prices and services. Question 4. What is the liability of a common carrier of goods? A common carrier of goods is an insurer of the safety of the transported goods and is liable for loss or damage regardless of fault unless the loss arises from acts of God, acts of public authority, inherent nature of the goods, acts of the shipper, or acts of a public enemy. Question 5. Why does the law require every carrier to have its printed bill of lading form approved by a government agency before adoption? The law requires every carrier to have its printed bill of lading form approved by a government agency before adoption because the shipper does not have any direct voice in the preparation of the bill of lading, and the bill of lading limits the carrier's liability. Question 6. How long does a carrier's high degree of liability last? A carrier's high degree of liability lasts only during transportation. After that time, the carrier is liable only as a mutual benefit bailee. Question 7. What is the difference between a straight bill of lading and an order bill of lading? Under a straight bill of lading, the consignee alone is designated as the one to whom the goods are to be delivered. Under an order bill of lading, the goods are shipped to a designated consignee or order, or to the bearer. The order bill of lading must be presented before the carrier can safely deliver the goods. This is not true of a straight bill of lading. Question 8. When does the liability of a carrier of people for the passenger safety begin and end? The liability of a carrier of persons for the passenger safety begins as soon as passengers enter the terminal or waiting platform and does not end until they have left the terminal at the end of the journey. Question 9. Is a common carrier liable for injuries to a passenger caused by a fellow traveler? A common carrier of passengers must exercise extraordinary care and is liable for injury to a passenger by fellow passengers only when the injured party is without blame. Of course, the carrier may have a cause of action against the fellow passenger or passengers who caused the injuries. Question 10. How may a carrier of people limit its liability for the loss of baggage? A carrier of persons may limit its liability for the loss of baggage to a fixed maximum amount stated on the ticket. Question 11. What is the liability of a hotel for refusing lodging for an improper reason? Damages, including exemplary damages, to the rejected person. Question 12. If a guest refuses to pay for services rendered, may a hotel sell any possessions left behind to pay the charges? Yes, provided any residue is returned to the guest. This concludes our lecture and question and answers for chapters 13, 14, and 15. The question for this particular lecture is, who was the second player inducted into the NFL Hall of Fame at the University of Southern Mississippi? And the answer is Brett Favre.